Maybe you're new to the world of non-disclosure agreements or NDAs. Sometimes they're referred to as confidentiality agreements, same thing, or other similar types of agreements. And I often get asked, when should I use one? When should I sign one? Is it okay to sign the one I've been provided? Non-disclosure agreements generally have two kinds of things in them. They'll define a kind of information that is to be protected. Maybe it's a particular book or a particular paper or general categories of information. And then they describe two things: to whom it can be disclosed and when, and what kind of use can be made of it. Most commonly, companies will sign a non-disclosure agreement that's mutual if the two of them are entering into negotiations for an agreement, and they'll need to exchange information about one another's products or about their business plans. They don't want that information to become public, and so they sign that information with a description of a purpose that says you could only use the information obtained under this agreement for purposes of deciding whether to go forward with a transaction between the parties. But it cannot be disclosed to anyone other than, and the agreement will explain who those parties are. And so the question is, when really should somebody sign one? Now, if you're an individual, say an employee who's been asked to sign one for your company, you may have no choice but to sign one as a condition of employment. And you should know that not having signed a non-disclosure agreement does not relieve you of confidentiality obligations related to your employer. Your employer's information is the employer's information, and disclosing that information, even if you've not signed a confidentiality agreement, may be a legal problem, might be a violation of trade secret rights of the employer, for example. But as between companies, it is very common and good practice that before entering negotiations for a larger contract of some kind, that companies would sign a non-disclosure agreement, an NDA, if they are going to exchange sensitive information. Now, you should know that as a condition of having trade secret rights in the first place, you've got to take reasonable actions to protect the confidentiality of the information. If you don't, if you have freely allowed confidential information to be provided to a prospective business partner, let's say, and then later that information becomes public or is disclosed and the trade secret value is lost, a court is unlikely to be willing to enforce the trade secret rights. A court won't protect you if you haven't taken reasonable steps to do the same related to confidential information. Sometimes I like to define confidential information in an agreement as proprietary information, but when we're saying proprietary information, we're typically saying information that is subject to reasonable efforts at protection and which has value by virtue of the fact that it's not been made generally known to the relevant markets. And so you should sign that non-disclosure agreement if you are going to be disclosing information that you're later going to need to protect. It's not a matter of trust in your partner or anything like that. You must have taken reasonable steps to do so. Now, disclosure to your lawyer, for example, doesn't require an NDA because lawyers are already under obligations of confidentiality if they have a lawyer-client relation with you. If there is not a lawyer-client relationship between the lawyer and the individual who's disclosing information, that lawyer is not subject to the same confidentiality rules, and you will have disclosed information without proper protection. So beware of that trip up as well. If you are signing a later agreement and you've already signed an NDA, you'll often find that the contract itself contains non-disclosure terms and that those will supersede a prior NDA, and that is perfectly appropriate and fine. Or you may find that there is a previously executed NDA that you can incorporate into that contract by reference to it and say that those terms still apply to the relationship under the contract. If you have questions about NDAs, I encourage you to take a look at the forms that are available on the website, and hope this helps.